So in this segment, we're going to be talking about a judge dismissing the Unionist challenge to the Northern Ireland Protocol. Again, this is, I think, the second time that this has happened, which would make sense given that it went to the Belfast Court of Appeals. So this from the 14th of March. Tried to move this one along because this story is great. So the Northern Ireland Protocol is lawfully enacted and must take precedence over centuries-old legislative clause on trade with Britain, the Court of Appeal in Belfast has ruled. The judge dismissed a pan-unionist challenge to the post-Brexit trading arrangement after finding that it subjugates part of the Act of Union 1800 based on the sovereign will of Parliament. And essentially the judge's ruling was that a new Act of Parliament can get rid of an old Act of Parliament. Really, that's what this kind of hinges on. Northern Ireland's constitutional status within the UK remains unchanged, they held. Lady Chief Justice Dame Siobhan Keegan stated, "This case is far from one where a court would even begin to complicate whether it could intervene, as the appellate suggests." So essentially saying this is not within the court's remit. This is not for the court to decide, Northern Ireland's place in the Union, I guess, and that the Northern Ireland Protocol has impacted Northern Ireland's place in the Union. The Act of Union is very old, and it was changed effectively by the House of Commons. They put a trade board in the Irish Sea. They can't go back and say, we need to get rid of this via the courts. It's not within their remit to do this. Implemented at the start of the year to prevent the creation of a hard Irish border. That's what the Northern Ireland Protocol did. The protocol means Northern Ireland remains in the EU single market for goods, which has helped Northern Ireland a lot. Trade checks on produce entering the north from Britain has created a de facto customs border in the Irish Sea, but let's not forget it was debated heavily in Parliament. It was the Prime Minister and his chief negotiator at the time, Frost, who decided on this, and they ran on it, won an election on the back of it in part, and implemented it. You can't say this is illegal or whatever, because the British government decided this. It went through Parliament, okay. It wasn't illegal by any international law. In fact, the Northern Ireland Protocol is a part of international law now. A High Court judge last year found the Withdrawal Agreement Act which introduced the protocol conflicts with Article 6 of the Act of Union, drawn up to ensure equal trade footing between Britain and Ireland. However, he ruled that the new legislation overrides older legislation which cannot obstruct the clear, specific will of Parliament. Just like when Parliament said slavery was okay, they then changed the laws to say that slavery was not okay. These people have gone to court saying, they can't do this because the Slavery Act, blah, 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 says we can. You can't. Newer acts of Parliament can repeal older acts of Parliament. That's how it works. Those findings were appealed on the basis that the Act of Union has legal supremacy with no power for the implied repeal of the constitutional statute. So essentially saying, the Act of Union overrules new rules, which doesn't really make sense. The appellates argued that a legislative prohibition on any trade disparity with Britain renders the protocol invalid. So essentially saying, because Northern Ireland isn't on equal trade footing with, say, Scotland, that means that the protocol is invalid because of that, which isn't the case. And so it doesn't, their arguments don't make sense, and they wasted a lot of money on this, and I just wonder who's funding all these legal challenges. The court found that Article 16 of the Act of Union has been modified by the terms of the withdrawal agreement without any implied repeal. So they're saying it's fine as is. It's been changed slightly, but the Act of Union is still there. It's not been repealed, it's just been changed. Parliament was clearly cited on the protocol, which was the end result of protracted, transparent, debated, informed and fully democratic process which decided arrangements for Northern Ireland post-Brexit, the judge had ruled, which is true. It was debated a lot in Parliament. There was even an election partially on the back of this, so we got Brexit done, because this was one of the things that was stopping Boris Johnson from essentially getting Brexit to happen, because of the Northern Ireland. The situation in Ireland creates a massive hole in the EU single market, which they didn't want to create. So what they did was they said, look, once you come up with a border solution for trade going between Northern Ireland and Ireland, then you can leave. And then Theresa May couldn't come up with anything. Some people are talking about technology, even though there aren't any borders that run technologically like that. Not really. Boris Johnson again turned a backstop into a front stop. That was the only way they resolved it. So for them to argue, no, if they're trying to argue that, no one could have foreseen this kind of thing, like they knew this was going to happen. The extent of which can be argued slightly, the extent of the trade disparity they can argue about, but on the whole, they knew they were going to put a trade border in the Irish Sea. The terms were settled and made law after a long parliamentary process, and it cannot be seriously suggested that Parliament was unaware of the changes that it may be wrought. And essentially saying Parliament knew what was going to happen. You can't argue otherwise, because otherwise you are kind of arguing incompetency, in my opinion. But I don't think the judge wanted to go there. With the previous acts of Parliament subject to the Withdrawal Act, she added, this means that the terms of the protocol take precedence. Essentially saying, the Withdrawal Act reigns supreme over the other things. Further grounds of challenge based on claims that the protocol is incompatible with the Good Friday Agreement and breaches the European Convention on Human Rights were also rejected. I mean, no, the Northern Ireland Protocol protects the Good Friday Agreement, and for it breaching the European Convention on Human Rights, I have no idea what the hell they're talking about there. With a separate challenge by Belfast man Clifford Peoples, similarly dismissed, the judge confirmed, we've determined that none of the legal arguments presented by the appellates prevail. Accordingly, the appeal must be dismissed. And so essentially they've been slapped down again. Brexiteers, you got Ben Habib here, Brexiteer, Kate Hoey, don't know who this dude is. They wanted British courts, British laws, all this stuff. Well, you got what you wanted. You've been slapped down again by a British court. So it's just a question of what are these people going to do next? Are they going to go to the Supreme Court in England? I don't know, but it's pretty wild. I don't know who's funding this, because the last time when I covered this before, they had a really high priced lawyer that was representing them, like a really really well regarded one. So the question is, who the hell's funding all these legal challenges? Because if they, there are real world problems going on where they could use this money instead of doing frivolous court cases and wasting taxpayer money. They could donate this money to good causes, be that in Britain or abroad. But instead they're wasting everyone's time with these frivolous legal challenges. And the only other thing I've got to say is, Ben Habib, what are those? But I'm going to leave it there. Let me know what you think in the comments below. Like, comment, share, subscribe. Support the channel on Patreon if you can. And hopefully I'll see you in the next one.